in their possession to establish a conviction of obtaining by false pretenses. Yet, the expert witness DW2 has appeared before the court to clearly establish that Apple Inc. does not manufacture devices with a facial ID feature. Furthermore, my lord is guided by the case of Ezenwa and the state, where my lordship established that when there is doubt regarding the identity of an entity, it must be resolved in the favor of the accused. Furthermore, even more damning are the inconsistencies in the timeline. My lord, the EFCC's forensic telecommunication call report was purportedly created in March 2025, yet devices were not seized from the defendant until December 2025. Yet, the EFCC has told the truth that the call that they analyzed from the telecommunication company is the same one that was on mapping. Furthermore, the defense has tendered the police extract and investigation report labeled exhibit DF1 through DW1, which proves that Mr. Victor Chijioke was not in possession of those devices at the material time that the crime was committed. Therefore, the prosecution has failed to tender and leave evidence that clearly established that Mr. Victor Chijioke was the one that indeed sent those mails. Furthermore, my lord, there is an absence of a knowledge of falsehood. My lord, the prosecution cannot give positive evidence that Mr. Victor was aware of any false pretense. The prosecution may point to the UFC bank statement. My lord, that bank statement is not before the court, as it lacks a label for an exhibit. Furthermore, the property purchase report is labeled exhibit P3 to suggest knowledge. However, uncontroverted evidence of DW3 clearly established that the account in question, the account which was proved as a vital element of obtaining by false pretenses, is that the victim must have been used to transfer ownership of the property. Yet, the prosecution has failed to establish that any amount of money was indeed transferred, as no such account exists. Furthermore, my lord, I will bring to your remembrance that there are material contradictions in the evidence before this court. As the email that was requested, the pretext, when the pretext emanated, requested the amount of $5 billion. However, the forensic report that was tendered before this court clearly shows that the amount that was received by the accused is $500,000. My lord, these inconsistencies in figures are essential to proving the guilt of the accused, as the amount of the charge is an amount of $5 million, which the prosecution, in establishing their case, has clearly failed to establish. My lord, furthermore, there is an absence of intention to defraud. Mercy passes beyond, mercy real. The defendant cannot be convicted unless it is proved that he was of a guilty mind. My lord, the prosecution relies on the property purchase to show intent. However, the defendant has established in DW2, my lord, that the defendant was not in possession of those devices, as those devices had been hacked at the material time wherein the crime was committed. Furthermore, my lord, the defense has failed to prove inducement and transfer of interest. My lord, the evidence before my lord that relates to the CAC certificate of non-registration, exhibit D4, which the prosecution tendered to prove that Victor owns Cardinal Rock Limited, the company that the money was laundered to. Yes, evidence before my lord, uncontroverted if I may have, clearly shows that Cardinal Rock Limited does not exist. As if my lord may even at the certificate of incorporation, the individual who was purported to be the director general at the subsequent time was Hussein Ishaq Magadi San, did not take office until October 2023. Yet, the name on the certificate of incorporation clearly states Mr. Ishaq when the company was incorporated in 2021. My lord, this has been the story that the prosecution has come to establish before this court. One evidence establishes a fact issue. The other evidence is inconsistent. My lord, therefore ask that what has the prosecution come to establish? My lord, the defense furthermore brings to your remembrance that if the account does not exist, then it cannot be established that there was indeed a transfer. And if there was no transfer, the prosecution has failed to prove that Orion Global successfully transferred the sum of $5 million. My lord, you cannot convict a man for obtaining money that never arrived into an account that does not exist based on a bank statement that IGBOKWE clearly establishes does not belong with UFC Bank. Therefore, my lord, the prosecution has failed to prove that that the defendant did induce the transfer of ownership. My lord, we conclude by saying, at the beginning of this case, the prosecution apologized for failing to tender evidence, for failing to front-load evidence. My lord, Mr. Victor stands the very high punishment of facing imprisonment, a violation on his personal liberty. The prosecution in the course of this case has clearly violated his fundamental rights and seeks to secure a conviction on documents that were not afforded to the defendant to even have a chance of contradicting. My lord, we therefore submit that not only has the prosecution failed to establish that Mr. Victor IGBOKWE is guilty of the offense of obtaining by false pretenses, they have also violated his fundamental rights and seek to find a scapegoat for all the years of criminality that our great country Nigeria has. That will be all my hand.
All right, thank you. Defense, prosecution.
May it please your lordship, from the preponderance of the facts and the evidence used in this court, it is as clear as daylight that this case is not about mistaken identity. It's about whether a man can build an empire on lies, fraud, and stolen money, and still hide behind glamour. The evidence has spoken loud and clear that the defendant was not innocent. He is a prototype of the notorious fraudster, Hush Puppy. My lord, the issue before this court is whether, in view of the evidence led, the prosecution successfully proved the charge beyond reasonable doubt. The answer is yes. The Supreme Court, in the case of Good versus FRA, IFA against the state, Ronke against the Federal Republic of Nigeria, has judicially affirmed the provisions of Section 419 of the Criminal Code Act and Section 1, Subsection 1, and Paragraph A of the Advanced Scheme Fraud and Other Fraud-Related Offences Act, that the offense of obtaining by false pretense is committed when the following elements are established. First, that there was a pretense. Second, that the pretense emanated from the accused person. Third, that the pretense was false. Fourth, that the accused knew of its falsity and did not believe in its truth. Fifth, that there was an intention to defraud. Sixth, that the thing is capable of being stolen. Seven, that the accused person induced the owner to transfer his own interest in the property. My lord, the prosecution has set out the elements of the offense, and as the Yoruba adage says, Ocho Gobolitoli, Ocho Gobolitolomu. Every day is for the thief, but one day is for the owner. Today, my lord, is that day. False pretense, my lord, as defined in this case of Abi versus FRA, to me, a representation, whether deliberate or reckless, made by word in writing or by conduct. My lord, this case did not begin in isolation. It began with a mutual legal assistance letter from Interpol sent to Nigeria, calling for the investigation of the Nigerian national linked to a sophisticated international cyber fraud scheme. The prosecution witness 1 testified to this fact, and the letter was admitted in evidence as Exhibit B1. That request triggered a lawful investigation, and that investigation consistently and unmistakably pointed to one person, the defendant, Victor IGBOKWE. In the same way, the investigation relies on trails, digital trails, financial trails, and communication trails. And as the PW2, our forensic expert testified before this court, the digital footprint of this fraud all converge on the defendant. My lord, the most compelling evidence did not come from a stranger. It came from the defendant himself, voluntarily and in the presence of his legal practitioner. My lord, through the PW2, the WhatsApp chats extracted from the defendant's SIM phone, duly admitted into evidence, were tendered before this court. Those chats reveal coordination, they reveal planning, they reveal deliberate intent to deceive the victim company. Furthermore, PW and identified the fraudulent email sent to a company under false pretense. She identified the forged board resolution authorizing payment of outstanding debts for Ironbush. She identified the bank confirmation letter, validated the new account details of Cardinal Rock under the control of the accused. All these documents were admitted in evidence. Those documents are not mere papers. They are instruments of deception. They were crafted to mislead, and they were designed to create legitimacy where none existed. The telecommunication evidence further details how a phone call meant for Ironbush was deliberately redirected to affirm the transfer of money into the account of Cardinal Rock. My lord, when the PW1 searched the defendant's residence, gadgets were recovered. A MacBook and 2 iPhones, along with certificates of incorporation of the shell company. My lord, this company was not trading. It was not providing services. It existed on paper, and they were used to receive and launder funds falsely obtained. My lord, in this case, technology was the tool, forgery was the method, pretense was the strategy, and money was the goal. My lord, each witness corroborates the order. The international request led to the digital analysis. The letter led to the charts. The charts aligned with the fraudulent emails. The emails aligned with the directed calls. And the call aligned with the money movement. And the money aligned with the shell company. This is not coincidence, my lord. The defense may attempt to raise doubts, but doubts must be reasonable. It must be real. It must be supported by evidence. What we have heard from the defense are denials. But my lord, denials are not defense. We have listened carefully to the defense and their witnesses, and we tell you that at the end of this case, their defense is as weak as the wall of Jericho. And we tell them that their case is going to collapse like the Nigerian national grid. My lord,
Order.
my lord, the defense case is riddled with contradictions, inconsistencies, and assumptions that cannot withstand scrutiny. Let me walk your lordship through this point clearly. First, the IPO claimed that the accused was robbed and his devices were taken from him. He cannot explain the chain of events that led to the fraudulent transaction. The IPO mentioned that the devices recovered were parts, my lord, parts of the defendant's collection of devices, not all the devices. Moreover, the police extract and recovery report do not contradict the prosecution's case. They confirm that the devices were recovered, but recovery after the fact does not erase digital fingerprints. The prosecution witness 2 shows that the accused had exclusive control of the devices at the time the fraud occurred. The DW2 testified that following the loss of his gadgets, the defendant contacted them. There are no that device. My lord, another device. This shows that the defendant has other devices. My lord, the fraud itself was executed using the account numbers and cardinal rock that the accused presented to Orion Globe. Whether the company is officially registered or not does not negate the fact that Victor used this instrument, forged documents, and created a credible corporate facade to extract $5 million. Third, the bank manager's testimony, claiming that the account numbers were fake, is directly contradicted by the evidence tendered by the prosecution. The emails, forged account statements, and bank communications were received, verified, and acted upon by Orion Global. The bank, whether or not it had a real executive named in the forged documents, was relevant to the fact that Victor orchestrated the fraud. What matters, my lord, is intentional deception and acquisition of money in a false pretense. Fourth, the Apple cybersecurity expert claims the devices were in lost mode and the Apple ID was locked out. Again, my lord, this testimony does not align with the digital forensic evidence. The forensic expert PW2 already showed that the email sent and the device activity were under victim's control, and biometric authentication. My lord, biometric authentication. The defense suggestion that someone else used the device is undermined by the secure digital trace linking the accused exclusively to the crime. Through the investigation carried out by Interpol, let me be clear. My Lord, the defense narrative requires this court to believe in their non-root story of a perfectly timed and coincidental chain of third-party fraud, where multiple devices were all manipulated by strangers at the exact moment and in the exact way they served their kid story. That's their Nollywood story will not have a happy ending. My Lord, the picture here is clear. The claim device text does not account for exclusive access and digital traces. Second, certificates of non-existence of companies do not negate the fraud committed using forged corporate documents. Bank audit logs and account non-existence does not erase the intentional deception or misrepresentation used to acquire $5 million. Apple's lost mode scenario does not align with forensic evidence, email timestamps, biometric authentication, and secure device access. My Lord, we therefore respectfully urge this honorable court to find that the prosecution has proved its case beyond reasonable doubt and has been stated by your learned brother, Justice Oguta. In the case of Bakare versus State, he said, the prosecution only needs to prove their case beyond reasonable doubt, not beyond all shadows of doubt. My Lord, we urge this court to hold and adjudge that the defendant, the accused, is guilty as charged. That is because justice demands it, the evidence supports it, and the law requires it. My Lord, Lord Denning said, justice must not only be done, it must also be seen to be done. Much obliged, my Lord.
Any reply from the floor?
Yes, my Lord. My Lord, I think it's fair proceed. The defense is the fair proceed. My learned brother, J.D.
In 10 minutes.
Thank you very much, my Lord. My Lord, this reply on point of law seeks to pick one element in the elements needed to be proven for a charge of obtaining by false pretenses to be established. That one element, as stated by my learned brother here, and he has stated that the Supreme Court, in due state, has stated that there has to be a transfer of ownership, my Lord. My learned brother here on the other side has come to say that the fact that the company that the amount was transferred to does not exist, does not matter. He has also stated that the fact that the account number that the money was transferred to does not exist, does not matter. However, my Lord, this is the only way to show that there was a transfer of ownership. How can we transfer ownership to something that does not exist? Therefore, my Lord, we submit that the prosecution has failed to show that there was indeed a transfer of ownership, and as already been stated, all of these elements have to be proved cumulatively. If one is not proved, then the whole charge is not proved, my Lord. Since we have shown that there is no transfer of ownership, the statement of my learned brother on the statement of law that it doesn't matter collapses, my Lord, as the transfer of ownership is a very vital element to the crime of obtaining by false pretenses. Thank you very much, my Lord. May it please the court.
All right, thank you. Gentlemen, you will give me a few minutes to go through your submission and prepare a very short judgment. I've also been directed to, based on certain parameters, to, assess your performance, the defense, the prosecution, and I'll do that also. Immediately I have read my judgment. I will just rise for a few minutes to go and consider it. I will just take about 15 minutes. I won't be long, or even less, because it's a summary judgment. It's not a full judgment. So you give me time, and I will appreciate that everybody remains seated while I go in and come on to the next 15 minutes. I will sit again at exactly 2:45. Thank you very much. All right.
All right.
So you can't pass the front. When? It's okay like this.
Where is Tiwa?
Do we need to stop it?
No. Just be showing what's going on. Sorry.
Good afternoon, everyone. I think we're quite agree with me that was a riveting battle of wits on this very stage. And I can't wait to see which side takes the judgment call. But before we get into further ado, we would like to appreciate someone who was very instrumental in bringing this and tuning our council, in bringing this very competition to life. I have to recognize Mr. Victor Opara, SAN. Please can we join our hands together for him? Thank you very much, sir, for your sacrifices. We don't take it for granted. And also, we do know that this is a very big monka. In fact, this is the first of its very kind, and it's a very big deal. A lot of effort has gone into this by numerous stakeholders, but there is one that must be recognized especially, and I can't do a good job of that. We have to usher to the stage none other than our dad in this faculty, Dr. Lisa Adeyoko. Please become more enthusiastic. Let's keep clapping until he gets on stage. Okay,
But which class you are by?
pardon this
Eh?
horrible mistake. We have to also recognize who got to put it there. Can we jump our hands together?
Is it online? Physical. You say it's physical.
This is the coordination of Young Members Forum
Eh?
of International Nigerian Maritime
Say
Law.
that. Attendance is perfect.
Thank you very much, sir, for coming. We really appreciate you.
Thank you, the guests, for coming. Before I call on the honorary the man who I'm so passionate about, who was a city supporter of what through my democracy in our students. I'm talking of no other person before. My mentor, maybe he doesn't know, but he was a mentor. He was my roommate at Nigerian Law School, started his part with me, and the honestly, which never did. That's make an effort. So Mr. Mike IGBOKWE, senior before I call him the state, I want to take to appreciate our faculty mentor who worked in every position. I saw that person for distinguished professor that was senior in the year. Thank you for always thank you for being here. So this is a mentor of mentors. They are also my former departmental head of department, no other person but Professor Amokari Sina Nigeria. Now, again, also almost at time, I just want to say that this initiative is that of our ABD of Incorporated Faculty of Law, Professor Adola Sami, senior and Nigeria, who said to me that, sir, I know that you have garnered level, Lore, really shortest period of being Mr. Professor. But I want more. I don't want you to be coming with personal or in the history of mankind in Nigeria, University of Lagos have to be the first to have won the most prestigious award of multi advocacy in the world. That gets up by coming home with the Great Street Award of Africa and the Washington DC in the US. I was student there and the Scope Award. And he said we should not make it personal alone. We should also investigate part of those our EA and part of law. And that brings about these chambers. So the chambers competed at the plenary round and the two red chambers emerged at this final. And Mr. Michael IGBOKWE, Senior of Nigeria, undertook to sponsor this session. And I want to say that all the expenses paid, fully paid by me. And this will not be possible if not because of the support of his wife. This is IGBOKWE. So on that note, I will call our honorary of today. This session is part 2026 Incorporated Mock Trial Competition. Mike IGBOKWE, Senior of the Edition. So, in the moment, we'll call it off to come and see the token that we have from the Faculty of Law. Please, on the one. I want to call my dean. I need support on the stage. I need. But we'll take the city back for my Lord's award. Thank you. This award of appreciation, this award is presented to Mr. Mike IGBOKWE, Senior of Nigeria, for your generous contribution toward the success of the Incorporable Mock Trial and your dedication to helping the next generation of lawyers develop courtroom advocacy skills. Presented by the Mood Society Greenland and the Incorporable Mock Trial, Mike IGBOKWE SCM edition, on this day, Thursday, 11th of February 2026. Thank you.
Ask the two members that are here to present, Mr. Lanet of Ministry, Prof. Prof, please join us. And then Victor H. Professor Amokai, please. I'm sorry, I still have some senior lawyers there who have been here all day. I want to appreciate all of you, but the state is just big enough for all of us. Well, I want to thank God for making this possible. I believe that without God we can do nothing. You know, and then to also thank the professors and lecturers in the Faculty of Law, University of Lagos, for making this event possible. Everything you did, especially the day. One thing I found out about him is that he's a man who believes in excellence. Excellence. He likes to see good results. I worked with him, you know, as a member of the student external member. I worked with him. And also as someone who is a senior advocate of Nigeria, I have seen his vision. I have also seen the way he delivers, you know. So when he mentioned this to me, first I thought, well, it would be a way of supporting his vision. Okay. Secondly, as an alumni of this university faculty, I thought I should find a way of supporting my alma mater. Then, what is more, you students, you are the future of the Nigerian legal profession. As part of our social responsibility, corporate social responsibility, we thought we should give back to the society through you by encouraging you and inspiring you, to be greater lawyers in future. And I just want to appreciate my brother here, Mr. Victor of our essay, himself and Mr. Olaleko were the two senior advocates that I know, also very good in criminal law. And I told them, please, this is what is going on. I will want you to help me train those who will participate in this particular meeting. Would you agree? It's not easy for us senior advocates of the good time because clients are pulling us here and there. Okay, for the devoted time, they said, this is you, we're supporting you. And they gave the time, gave the resources just to make sure that the participants were trained. I thank you so much, Then, of course, see, you guys are very lucky. Because I went to this university, he was one of our lecturers, although he was taking the period there, but you guys did not give us this kind of thing. When we were here, I'm talking about 1980, 1983. There was nothing like this. And for someone with a vision, at that time, especially also Professor Lisa, God bless you, he don't talk for it, I'm professional, so you see it, okay? Can you imagine that? To have come up with it, we never had this opportunity. We did it, and like he said, he told me that he's an expert. I said, yes. What he's doing here is what I know universities are doing. When I went there, I also found that that's what happened. And then it's this thing about, private university collaboration, private sector university collaboration. Whereby they bring the best from the society to collaborate with the university, which is to making sure that the students are better. They're better trained. And they prepare you for the outside world. That when you come back, you will not be new. All the things you're doing here at your level make it a lot. And I want to give you kudos. Yes. There are some errors I just want to correct because it's also a learning process. I'm not sure. During my youth service, the first case that will ever come my way, I couldn't handle it. I told him, the guy was my in-law's friend. I told him to please go to a friend of mine. Because I didn't have the experience. I couldn't go. I was a tribunal, okay? I didn't. And when I joined Mr. Hikelan's direction of Lesson who trained me, it was not the very first day I started going to court I was able to cope with the court fight, and I was very shy person. Very shy person. But as time went on, because the practice made perfect, I began to overcome that shyness, speaking in public and stuff, and then I grew my advocacy skills. What you must find out that knowledge is endless. You continue to grow. You are seeing here, I went back to school at age 62 to study. Everybody said to me that when you're too old to study, does not know what to do. Especially today, what's going on in communication and education, we have so much to learn. Okay, so as I was saying, you will find out that what you have learned here will stay with you forever. You will never forget. And somebody thinks that you didn't do well, this is important. You don't call more than one cancers. Whether it's one cancer or two or more cancer. So you have to pay that. I think one of you, when the judge was addressing you, said that, no, you have to speak that. And two lawyers don't stand at the same time addressing the court. The moment someone gets up either to object or otherwise, you see that. And one of you asked the defendant to told the court to allow the defendant to speak that. That's a good one. But after the court has given you that is done, then you should thank the court. It's one of the things you respect. Okay? So let's keep in mind. I don't want to have to blame you because these are of course. You have got it. It's good to correct it back. You're still learning. Even when you come out, you still be learning. You know? So in closing, I want to thank the dean of the law faculty of University of Lagos and every professor lecturer in that faculty that made this possible. And I wasn't surprised when the dean was speaking here and said that the students are our lives and that they are investing in you. Can you imagine investment? You say a lecturer or professor investing in you. How much are you paying him? Yeah? You don't know what that means. It shows the kind of heart they have to work, and all of them here, how they want you to be the best. Eh? The best of the best. So please don't take it for granted. You know, and anytime they call on you to take part in things of this nature, don't just run away. Stay seriously, take active part in it, because their time is a lot of money. Effort. They're making a lot of sacrifices to make you better lawyers tomorrow. Don't take it for granted because you're getting this on the platform. Okay? So I wish all of you success in the exam, and I pray that you will also be future Supreme Court justices and then now the future of Nigeria. If you choose to go that route, because you don't have to be a practicing lawyer or a judge, you can also do as a politician. But make sure that you have integrity. Integrity, character is key. Anywhere you go, let your name speak for you. Let people know you by what you stand. No corruption, no lies. Somebody was caught